The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. Our last case for the day is Cummings versus Carroll et al., and we will hear from the appellant.
Thank you. If it pleases the court, my name's Raul Taylor, and I'm with Warden Smith down in Wilmington. I represent Berkeley Investors and one of its members, George Bell, and I'd like to reserve 2 minutes for rebuttal. The first thing I'd like to point out is there is a distinction in the potential liability of Berkeley Investors and Bell. Berkeley Investors own this property, entered into the contract to sell the property to the Cummings, and entered into the listing agreement with its realtor, Robert Carroll. So to the extent that this case develops into a breach of contract case such that the economic loss rule applies, then it is Berkeley who is liable and not George Bell. Secondly, to the extent any acts or omissions of Robert Carroll that should be imputed to his principal, the principal is Berkeley Investors and not George Bell, and I just wanted to make that distinction up front. The two claims against Berkeley and Bell that remain in this case for potential consideration today, and that the Court of Appeals determined should go back to Brunswick County for trial by jury on issues of fact, are negligent misrepresentation and fraud. And I don't want us to gloss over the fact that this is a potential fraud case, and that the Court of Appeals decision about what Berkeley and Bell knew or didn't know turns on the fact that a painter was retained to fix this leak and not some other professional, such that Berkeley and Bell would have to have made a reckless, at least, or a knowing misrepresentation of fact in order to support a fraud claim. And to say that because a painter repaired this leak, that makes Berkeley and Bell's knowledge tantamount to reckless, it doesn't seem supportable. On the negligent misrepresentation, there is a contract in place. The disclosure is made part of the contract. The contract, a contract claim appears in the complaint, and it's all economic damage. It's damage to the subject of the contract, and we would submit that the economic loss rule applies, whether the court applies it to fraud claims or not. If there's no fraud and there's negligent misrepresentation, then the economic loss rule would bar any claims against George Bell. Secondly, I want to talk mostly about misrepresentation today and whether there really was one. And if you look at the amended complaint, the plaintiffs were hanging their hat on information that Randy Cribb, the painter who fixed this leak, gave to them. And so in the complaint, it's alleged that he told Robert Carroll, our realtor, all kinds of things about how bad off this house was and how he was told to conceal damage, etc. Well, that didn't pan out because Mr. Cribb's deposition was taken and he didn't confirm any of those things. In fact, just the opposite. He said, if Robert Carroll told me to fix it, I fixed it. I'm a painter, I fix leaks, what I do, etc. So then the plaintiff's case turned to the Oak Island Accommodation maintenance records. Oak Island Accommodations was the property management firm that rented this house for Berkeley and Bell and did so from 2005 until they sold it in 2014. They rented the house, cleaned the house, did minor repairs and maintenance, and kept a maintenance log of what all they had done. But every entry in those maintenance records was explained away, and in fact, the Court of Appeal says we're not deciding this case on those maintenance records. In footnote number 3 to the Court of Appeals opinion, they said the maintenance records are immaterial. They're basing it on a January 20, 2014 discussion among George Bell and the other member of Berkeley investors Kim Durham and their realtor Robert Carroll. Well, that discussion was an email dated January 20, 2014 that George Bell sent to Robert Carroll, his realtor, and to Kim Durham saying, there's a stain on the ceiling. We need to paint it. We need to fix the leak, please. So we turn to that, and the genesis of this leak is an October 14, 2013 email from George Bell to Kim Durham and Robert Carroll when George and his wife Betty were staying at the house. This is 10 months before they sold it in August of 2014. And George says in the email, there's a stain on the ceiling. We need to trace the source of that leak, and then we need to do some painting. This is October of 2013. October 14th to be exact. October 26, 2013, an appraiser hired by Robert Carroll came to do an appraisal of the house to help them determine what we should be listing the house at. And the appraisal has photos of the interior of the house, says the inspection date was October 26, 2013, does not mention this stain on the ceiling, and says the sheetrock is in good shape. It's a sheetrock ceiling. December 2013, Betty and George come back to the house. Stain hadn't gotten any bigger. George sends another email, the offending email, October 20, 2014, and says there's water intrusion into the house. There's still that stain that's on the ceiling, and we need to do some more painting otherwise. And we need to trace the source of that leak and fix it.
Mr. Taylor, before you go too much further, I may be operating under a misunderstanding here, and if I am, please correct me. My understanding had been that the Court of Appeals based its decision to keep your clients in the case not so much on the specific leaks, but upon the testimony of Mr. Moore, who described extensive water intrusion, termite infestation, and other things going back a period of time. Am I misunderstanding what we've got before us here?
Well, I think that in part that's the case, but interestingly, Mr. Moore never was asked and never gave an opinion, and there's nothing in the record that says that what he found was in existence at the time that the house was sold and this disclosure was provided.
Did he say that it was something that, and I've read your discussion about the backward inference rule, and I've looked at the cases and don't need to worry about that, but at least my understanding was that Mr. Moore's testimony was that he had observed these various conditions that he had seen, that they had not developed overnight, that there had been attempts to conceal or at least make less visible these conditions by painting and other things, and that was the testimony upon which the Court of Appeals hung its hat. Is that wrong?
I don't agree that that's exactly his testimony. His testimony was that yes, there were bad water intrusion problems that he felt had been there for a while, although he didn't place them back. But we don't really dispute that there obviously there was something wrong with the house. What we're disputing is we had no knowledge of it, and there is no evidence other than what he said that maybe looked like there had been some painting done and that it was concealed, but he had no evidence that we did any.
Is it permissible, when you say there's no evidence, I would concede that I don't think anybody's pointed to any direct evidence. Is it your contention that there has to be direct evidence, or can inferences be drawn from the testimony of Mr. Moore? Obviously, I think your answer is going to be no for some of the reasons that you've already said, but help me understand your position here.
So all Mr. Moore said was that he found these problems and he saw where work had been done on the house in the past. Well, my clients didn't build the house. They bought it in 2005 from someone else. They had the same maintenance company or the same property management company who kept detailed maintenance records every time they went out there. There's been an indication that, yes, the doors in the house were replaced by Berkeley and Bell and Durham in 2012. The carpet was taken up and replaced with bamboo flooring. So yes, work had been done on the house, but there's absolutely no evidence, no matter what he may say out of the air. I would suggest that there had been a concealment of any problems with the house. And it seemed to me that the Court of Appeals, if you look at page 26 of the slip opinion and page 27, that and we're just talking about the knowledge. They said the record raises genuine issues of material fact regarding whether hiring a painter was unreasonable, such that Berkeley and Bell negligently misrepresented that they did not have actual knowledge of problems. And with the fraud claim, the same thing. It says the question of whether a painter's purported repair of a leak eliminated Bell's knowledge of water intrusion is an issue of fact. That's what I felt like the Court of Appeals hung their hat on in this case. And they talked about the significant water intrusion problems of the house, where there weren't any to the knowledge of anyone. And this leak that happened in October that was fixed in March and never resurfaced was, to me, what they were saying was the water intrusion problem, because they said in their note 3 that we're not basing our decision on the Oak Island maintenance records. And once that leak was fixed and it was reported fixed, then everyone on our side of the fence said, well, there's no need to change that disclosure statement because you don't have to disclose repaired items. And that is the testimony across the board in this case from all the professionals. And it's consistent with previous Court of Appeals case law that once something is fixed, you do not have to disclose it. And it all goes back to knowledge. What knowledge did they have? And is it reasonable to rely on a painter, really? So because that's who Oak Island Accommodations got a quote from, was East Coast Painting. And you'll note in that East Coast Painting quote that that's attached to the, as a part of the appendix to our brief, that there are no sheetrock repairs suggested. This wasn't a bad leak. And number 2, they said they were obviously looking for the source of the leak, because in a parenthetical out to the side of exterior upper deck, it says, I think this is the problem with the ceiling. So if George Bell and Robert Carroll were trying to defraud anybody, they sure weren't doing a good job of it, because they pushed this email right on over to Oak Island Accommodations, who got this quote from that painter, and then Randy Cribb said he'd do it for that and do a little bit more work than that. So the item had been repaired. It didn't show back up through all the inspections that were done once the Cummings entered into the contract, through all their visits to the house, through post-closing visits to the house. It never showed up until Thanksgiving. And so I see that my time is out. I'll reserve that other 2 minutes, please. Thank you.
Thank you, counsel. We'll hear from another.
Honorable Chief Justice, members of the court, my name is Clay Collier. I'm a lawyer in Wilmington. I have the honor in this case of representing Robert Patton Carroll and the RE/MAX agency with which he used to be affiliated. I would like to reserve 3 minutes for rebuttal, because it takes me longer to say hello and goodbye than everybody else. And I appreciate the presentation of Mr. Taylor. What you're going to hear coming after me is going to be better than this, but from the perspective of my client, who was the agent that represented Berkeley, and Mr. Bell was a part of Berkeley to market and sell the property, I would respectfully submit that the real issue is, can the agent for the sellers, in this case Robert Carroll, of property, be held liable for negligently or fraudulently misrepresenting or failing to disclose material defects that are not disclosed and in fact are denied by his clients, the sellers, and or the multiple professionals that inspected, evaluated, offered for sale prior to Robert, maintained or performed work on the property. That's a mouthful. But here's what Robert started with. As the agent that was going to market and hopefully negotiate and did ultimately accomplish the sale of this property for Berkeley. First of all, he got information from the Berkeley people themselves. And you see that in Mr. Bell's affidavit. That's at the record at page 34, Ms. Durham's at 378. Even up to summary judgment, they continue to deny any knowledge of any chronic water leak or rot or termite infestation or any of these things that are alleged in the complaint. Robert went beyond that. He went back and looked at the prior listings of other real estate professionals for this same property, because Berkeley had been trying to sell it for a while and had used other agents to try to market and sell the property. You can see that in his deposition at page 23, 24, 56, volume 2 at page 8. He actually gave the name of one of the realtors that had previously listed the property. When he looked at those listings, he saw nothing in those listings or those disclosures that would have alerted him to any potential problem. And Mr. Taylor referenced this. At some point, he engaged an appraiser when the first listing went by. Nobody nibbled, because remember now, look back in time, and you know that the real estate market was depressed at this point in time. And I think it's fair to say that Berkeley had bought high, and now they were trying to sell low. So after the first listing fails, Robert engages an appraiser. Mr. Taylor referenced it, this October appraisal. And you can find that appraisal at the supplement, page 461. Take a look at page 463, where it says that the property looks like it's 10 years old and not 12. No repairs or improvements needs noticed. At page 466, they put a price of $1,255,000 as the appraised amount. This is in October of 2013. He then, when he was under his contract, Robert had the right to be a dual agent, which would mean he would represent both sides. And he had some folks that approached some doctors from Durham that were kind of interested in the property. And so as a dual agent, he's representing both sides. They requested the maintenance records, and he got some maintenance records on the property. That's his deposition. He talks about that at page 135. And he talks about repeatedly in his deposition how those maintenance records all indicated that everything, whatever was there, had been repaired because the record said so. And if remedied, then like Mr. Taylor said, the law is if the matter is remedied and you believe it's repaired, then it's not a material fact that requires disclosure. So in volume 2 of his deposition at page 42 and 43, there was some question about, well, what about if you do a disclosure and say there's no problem, but then something happens and you show the house or somebody's interested before it's repaired, and Robert discusses that and says, hey, then you have to disclose it. But if it's repaired, then it's just not material. Then you have this situation with the stain on the ceiling, and you had these emails in October and January that Mr. Taylor has described. And so what happens? Oak Island Accommodations is consulted because they, being the property management company, are responsible for the maintenance of the property. And what do? They engage the services of a painting contractor, this East Coast Painting. That's at, I think, page 111 and 119 of the, and understand now, Oak Island Accommodations, licensed realtors, real estate professionals, they have to be under section NCGS section 93A-2 parens A, because they're offering the property for rent. So they have to be licensed, just like Robert Carroll, just like Brooke Rudd-Gagley. So here is another professional in the field that makes the choice of let's get a painting contractor. So there's your standard of care, and there's nobody that says anything different. He looks at that, he sees the thing, Randy Cribb agrees to do the work, plus a little bit extra. He does the work. We have the text messages, you've seen it, where he talks about, may have found it, but if that's not it, I don't know what it is. It's tight. We'll be getting a blowing rain. We did. It happens. Then you have a home inspection after contract. And remember, the home inspector said 3 days after it rained. Now the home inspection says windows won't open up. They're casement windows. The door under where the leak happened wouldn't open about 8 inches. And he says, you need to talk to the Anderson guy, and here's his cell phone number. He knew there was a termite inspection. He knew there was another appraisal. That's at page 490 of the supplement. And remarkably, the value is $1,252,000 in that appraisal. And take a look at that thing. It says it appears to be in good condition for its age at page 491. No major repairs or renovations noted. And the appraiser indicated the effective age was 8 years versus 15 or 20 or whatever. So he knows these things. All these professionals that he knows, he got a copy of the summary of the inspection report. All of these things should supplement or make him feel good about his belief that there's no material fact. So what happens then? Then the plaintiffs come and request an amendment of the contract. And they reference the home inspection report. They attach the summary. Ms. Rudd does her job. She says the owners are, quote, very concerned, unquote, about the windows and the doors and talks about the door that won't open but 8 or 9 inches. Remember now what the contractor said in his deposit or in his letter, that the structural integrity of many of the doors has been compromised and may be allowing the water to enter the wall cavities around the thresholds. That's the deposition exhibit number 1 of Craig Moore's deposition. So our position is that the law and common sense should dictate and mandate that Carroll should be allowed to rely on all of this information he's received from various professionals and believe that there's nothing material there. This supported Klaus versus Gordon. Is the very first one. Remember, that's the one with the appraisal. I mean, the surveyor that got it wrong with the ditch and the wetlands on his topo. But the court there says you can rely on another professional who in that field. That Taylor versus Gore, another Court of Appeals opinion, reiterated that. That was another case where there was a professional that had given some opinion on the condition of that property, and the realtor relied on it. It's reasonable. He's allowed to rely on the disclosure statement that was executed by his clients. The Dykes versus Long case there was a case where the folks believed that the condition with that porch and that front area of the house had been already repaired, and they said so on their disclosure statement. Kind of similar here, because we knew there was this water leak, and even Berkeley, I think through Mr. Bell, had told Robert, yeah, we'd had a couple of leaks in the past, but we always got them fixed. So everything's fixed. So from Carroll's perspective, it's reasonable for him to rely on the information at his disposal from multiple sources, professionals that should know and are supposed to know, and that realtors must rely on. I mean, as a practical matter, in our state, a realtor can't be a surveyor, an appraiser, a water intrusion contractor, termite, pest control specialist. This information comes to realtors, and they should be allowed to rely on those things reasonably. And under the circumstances, that's what happened here. To hold him responsible after all of the work that he did to confirm the information that he had originally gotten from his clients. And remember, all the way up till now, the clients still say the same thing. I didn't know about it. I didn't think there was anything wrong with the house. Then I would respectfully submit that would lay a burden on agents that would be too much. So now, but let's not forget that the significant failure of these plaintiffs to do their due diligence and to avoid the contributory negligence that is written all over this case. Now that the second question, the first question is important to my client here, but the second question washes out everybody. And I would respectfully submit what I've said already. The Cummingses are the most unreasonably reliant and contributory negligent plaintiffs in the history of our appellate jurisprudence. You look at the you look at what they did, and they got a home inspection, and the home inspection report said you need to contact this guy at Anderson Windows. They did not until after all of this was discovered. Why not? Well, it might be because Mr. Cummings had himself more knowledge and experience about windows and doors than anybody in the case. Anybody that's on this call right now. He ran a company that tested and inspected windows and doors for, golly, I can't remember how many years off the top of my head. So so a lot of knowledge. He's told you need to look into it. He knows that the doors won't even open. His agent is talking about it when negotiating an amended price. And yet he says, no way. He gets a termite inspection that recommends a termite bond, turns it down, says no thanks. So we would respectfully submit that under the case law that is in the briefs, that he under the McFadden versus Loof case, he ignored his home inspection. He didn't talk to his neighbors. The Callaway versus Wyatt case talks about that. He was in the business. Helms versus Holland, the plaintiff was in the business on these family care facility stuff. He knew better. He was a sophisticated businessman, just like what we talked about in RD and J properties versus Laurel Lee Ditton. Mr. Cummings was sophisticated. He was knowledgeable. He had the facts in front of him. He ignored them, and he moved forward to buy the property. And that is unjustifiable reliance, and that is contributory negligence. And this is a great opportunity to make that point as the court. I'd be happy to. Well, and that'll be all my time for now. Thank you.
Thank you, counsel. We'll hear from the third counsel.
Thank you, Mr. Chief Justice and Associate Justices. May it please the court. My name is Stuart Stroud, and I represent Brooke Rudd Gagley, Jim Goodman, and the Margaret Rudd and Associates, collectively the Rudd defendants. I would reserve 2 minutes for my rebuttal time. The Rudd defendants request that you adopt Judge Arrowwood's dissent and affirm Judge Hinton's order allowing summary judgment pursuant to Rule 56 of the North Carolina Rules of Civil Procedure in favor of the Rudd defendants. And I think a little bit more factual information is important in this case, especially with respect to the Rudd defendants, who were the buyer's agents, the Cummings agents. In the spring of 2014, Jim Cummings and his daughter had already identified this house for purchase before they ever approached Brooke Rudd Gagley and the Rudd firm. The facts are uncontroverted that the Rudd defendants had no knowledge of this house prior to this. They hadn't shown it before. They hadn't listed it before. They had no knowledge of this or any of the anything that had gone on with this house before they got involved. It's also important to keep in mind, as Mr. Collier just mentioned, that Jim Cummings is a sophisticated buyer. This is not a 25-year-old who's never bought a house before, who's just been in an apartment. Jim Cummings has bought and sold residential real estate, commercial real estate, and investment properties. So he is a knowledgeable consumer. He worked as a loan officer in a bank early in his career. And he worked in a business and established his own successful business, which specialized in the testing of windows and doors. So in every way you can look at this case, he is a sophisticated consumer. And that's the sort of the lens that you have to look through with respect to the actions or inactions of his agent. The sole remaining cause of action against the Rudd defendants is breach of fiduciary duty. It's set out in the original complaint as a separate cause of action, but fiduciary duty only refers to the standard by which the alleged negligence of the defendant is reviewed. It's still a negligence cause of action. There is no question in North Carolina the buyer's agent does have a fiduciary duty to the buyer. That is set forth in the buyer agency agreement and contract, and it's law. I mean, there's no question about that, and that's never been a question. However, the lower court confirmed that a negligence cause of action, which in our opinion would include breach of fiduciary duty, would be barred by the economic loss rule because of the buyer agency agreement and contract. When you look at the case law that defines breach of fiduciary duty, Brown versus Roth is the case that is most commonly referred to and is cited throughout these briefs. The fiduciary duty of a real estate agent is the duty to exercise reasonable care, skill, and diligence in the transaction of business entrusted to him or her in this case. In other words, what would a reasonable buyer's agent have done under the same or similar circumstances? Well, we know in this case that Brooke Rudd Gagley, as the agent who was representing the Cummings.
Mr. Stroud, just to make sure I don't lose where you're trying to go here, as part of that duty of reasonable care, there is a duty of disclosure of facts that either were known or should have been known, as long reasonably should have been known, as long as they were material.
Yes, sure. Yes, Justice.
And you're not contending that there's no obligation to make such disclosure either under the contract or as a separate matter of fiduciary duty law?
Under either the contract or fiduciary duty, she would have a duty to disclose any material facts that she was aware of.
Or reasonably should have known?
That's correct.
Okay, thank you. I just wanted to make sure I was following you. Appreciate it.
Yes, sir. In this case, the buyer's agent's duties, which are, the heart of this matter, are set forth and defined in the buyer's agency agreement. But beyond that, the North Carolina Real Estate Commission tells buyers or buyer's agents or real estate agents in general, what they should and shouldn't do in transactions. If you look at the Brown versus Roth case, that's a situation factually where the agent did not measure the house for square footage. She relied on an appraiser who had done that. Well, it turns out the appraiser was wrong. The reason there was a breach of duty there is because there's a specific North Carolina Real Estate Commission rule that says agents have to measure the square footage themselves. She didn't do that, so there was a breach of duty. That's not the case here. Brooke met every duty as a buyer's agent as set forth in the contract, such as obtaining disclosures, obtaining all documents requested by the buyers, coordinating inspections, and appraisals. The fiduciary relationship does not make an agent an insurer or a guarantor of each transaction or condition of the property. The standard for negligence, including fiduciary duty, is not hindsight is 20/20, and to rule otherwise is to make every agent liable for anything that's discovered with the house at any point in the future. In Brown, a specific duty was violated. In Klaus versus Gordon, the characters are a little bit different, but in essence, the point is the same as this case. In that case, the plaintiff argued that the agent breached their duty, their fiduciary duty, by failing to check flood maps. And the court said there's no evidence of any such duty. There's no evidence either in the contract, there's no evidence in the North Carolina Real Estate Commission rules that says agents have to check flood maps. And the court—
Mr. Stroud, if I'm reading Mr. Klaborowicz's brief correctly, he contends that a certain portion of the testimony of Mr. LaRoque, if I'm pronouncing that correctly, would tend to suggest that your client had a duty to inquire at least into the maintenance records. Would you comment on that argument?
I'll be glad to, Justice Irvin. What I would suggest to you is I'd go back and read Mr. LaRoque's testimony, which is part of the record, because what Mr. LaRoque said was that if the client needs it, if the client requests it, then it's her duty to obtain it. And we completely agree with that. But at no point did he or the plaintiff's expert say it is standard practice and the standard of reasonableness for any agent to ask for maintenance records. That is not the case. Now, if Mr. Cummings had said,
So basically your argument, your response to that portion of his argument is that the portion of the record upon which it relies doesn't support the contention?
yes, sir. Yes, sir. What I would suggest is he says that if he needed it and if he asked for it and she didn't get it, then she would have breached her duty, but that is not the case. Mr. Cummings' own testimony is that she provided him with everything that he asked for. And in fact, what she provided for, he did ask for, was the amount of how often the occupancy rate, how often the property rented. He asked for information about the income that was made from that rental. She provided all of that to him, but he did not ask for rental records. He went so far as to conduct his own investigation. He went and spoke with Oak Island Accommodations himself, made his own inquiry independent of anything that Brooke Rudd Gagley did, and he never asked for the maintenance records from them either. But based on the information he did receive, both in terms of the home inspection.
Let me make sure I follow what you're saying about the maintenance records. Are you saying that Ms. Rudd Gagley didn't have a duty on her own to inquire about the maintenance history of the property?
That is correct. There is no standard for a real estate agent, either in the contract, in the real estate commission rules, or case law, or anywhere else, that says maintenance records are part of the standard obligation of the agent to obtain. And that kind of makes sense, because if you think about it, unless a particular property has been maintained as a rental property and maintained as a rental property by a agency such as Oak Island Accommodations, such records probably wouldn't even exist. I don't keep those kind of records about my house. And so that, if that was something he needed or wanted to be able to make a decision, that was something he needed to ask her for. And it's easy
not
for him.
The agent's obligation. It's not part of the information that the agent advising the buyer should have known.
Correct. There's no standard anywhere in the real estate commission rules or anywhere else that says the agent needs to inquire about maintenance records. And if you look at Klaus versus Gordon, that's the exact point that they were making there. In fact, they go so far as to say mere inaction does not establish negligence in the absence of a duty to act. And that's where we are in this case. The fact that she didn't obtain those records in the absence of some duty saying that she should, or a request from Mr. Cummings, does not establish negligence on her part. She coordinated the inspections.
Mr. Stroud, you happen to be the third presenter of the defendants. I've got one broad brush question, and since you're presenting number 3, I just save it for you, and the other 2 can on rebuttal respond if they wish. But the defendants were the recipients of summary judgment on all of the plaintiff's claims, and you have expressly requested that this court adopt the dissent from Judge Arrowood. Because there is a general understanding that in negligence and fraud allegations that typically the term reasonable would suggest that such issues be resolved by jury. You use the term reasonable once. Mr. Carroll used the term reasonably, so you recognize reasonableness as being a part of this aspect here. Why shouldn't, as a general rule, these claims by and large go to a jury?
Justice Morgan, my response to that would be that Judge Hinton listened to 2 days of arguments on this case. She reviewed the record in its totality. She reviewed all of the depositions. She gave it careful consideration over the course of a month, and she found absolutely no basis for this case to go forward, that there was no evidence of negligence or breach of fiduciary duty or any of the other causes of action that were alleged against the Rudd defendants. And I think this court owes some deference to the Superior Court judges. The easy decision for her to make would have been to say, "Oh, it's a question of fact. Let's move on and start the trial." But that's not what happened. She spent a tremendous amount of time exploring this case, looking at all these depositions, and she came to that conclusion. And I think, including Justice Arrowwood, came to the same conclusion. And I think that that's the position that the court needs to adopt from the Supreme Court as well.
Is this an atypical case then that would take this kind of case away from the aspects of the general rule of reasonableness is determined by a jury? It just fits into that unique kind of case?
I think it is a unique case. Presumably that's why we're all here. But specifically in this case, with respect to the Rudd defendants, I think it's unique because the plaintiffs have not put forth any duty, specific duty, that's been breached, whether contractual or real estate commission or anywhere else, or from either of the two experts that testified. None of them have been able to present that as a duty. I would reserve my last 2 minutes for rebuttal. Thank you.
Thank you. We'll hear from the appellee.
Honorable Chief Justice and Justices of the Court, my name is Chris Kleborowitz, and may it please the Court. I represent Jim and Connie Cummings in a case that touches some important issues that deal with the requirements of homeowners that are selling their home to disclose things that they know about, the duties of real estate agents in the transaction, and then the duties of the buyers in that transaction. As the justices have noted in their questions, the facts and the law in this case are a perfect confluence of what we contend are some fraudulent concealments and lack of disclosure by the sellers and their agent, the breaches of the buyer's agent's fiduciary duty to use reasonable efforts, and then that is against the diligence of this buyer, and we'll talk about that within the context of latent material defects in this home. Now, when the law and the facts collide, a quote comes to mind: "Don't make what's interesting important." And respectfully, my colleagues have focused on interesting, but not what's important. For example, Justice Morgan, you asked about the reasonableness standard. Well, let's look at what this case presents. It is the reasonableness of homeowners with years of water intrusion not disclosing the same. It's the reasonableness of their agent knowing about those maintenance records and the years of water intrusion, not giving those records to Ms. Gagley. It's the reasonableness of that agent and the seller in relying on a painter to say, "I think I found the problem, and if that's not it, I don't know." It is the reasonableness of our agent with a fiduciary duty, who Mr. Stroud acknowledged knew nothing about this house, the reasonableness of her investigation to learn about this house. And then the reasonableness of the buyers in relying on home inspectors, termite inspectors, licensed real estate agents, appraisers, licensed general contractor or licensed electrical and plumbing contractors, and a qualified handyman to come in and tell them what they need to do in light of the inspection report. So let's focus on some of the facts that are important. And number one, we have to remember, everyone in this case has said this house was pristine. Not it looked good, it was pristine. What we also know is a fact that the residential disclosure form was not accurate. It was false. Mr. Carroll and the sellers knew that the representation that there were no known problems with that house was false. Because during that time, there was water intrusion manifesting itself as a 15-foot leak into the main living level of the house, manifesting itself, Justice Irvin, to your question, with rotten wood, buckled wood, and through the maintenance records, we see soft spots in the floor and other damage that existed. What we know from the facts and the emails is that Mr. Cribb, for 3 years, along with another gentleman by the name of Mike Sears, addressed repeated water intrusion. and the pattern came up. We fix it in the spring, it manifests in the fall. We fix it in the spring, we manifest in the fall. And then what we know is that our home inspector, because this house was pristine, found absolutely no evidence of water intrusion and no reason to do a more comprehensive moisture intrusion type testing. Now, what do we know about the maintenance records? Well, first, the Court of Appeals did not say that they didn't consider any of them. In the footnote, they said from 2005 to 2010 are the records that were at issue. But they specifically, on page 3 of their opinion, cite the maintenance records that Robert Carroll had in his possession. And that's the first.
Mr. Kleborowicz, just to ask you a fairly detailed question about these records to make sure that I understand what the record in this case says. I gather that there were approximately 3 years worth of maintenance records that were provided to, I think, Mr. Collier, and that the records prior to that 3-year period became available as the result of a subpoena that you sent to the maintenance company?
Yes, Your Honor, or Justice. And to be clear, it was a subpoena sent to Robert Carroll's wife, who is the head of maintenance.
But that she's not a party to
She
this
is not.
case, or I mean, she may have that tie to him, but we got to, in terms of what's admissible or what's not, I'm not sure that has any bearing on it. So basically, we've got 3 years worth of records the record reflects were available to Mr. Collier prior to the closing, and then these other records became available to you under the circumstances that you described afterwards. Is that right?
Justice Ervin, what I would say is that what we know is what Robert Carroll produced in this matter. We don't know what he actually had, but
I understand, but at least the record would tend to suggest that we know that he had the 3 years before that, and we can speculate about what he might or might not have had other than that, but we know he had the 3 years.
Yes.
Okay, thank you.
And what we know is he had them in his possession, and he made the decision to not provide them to Brooke Rudd. Now, there's another thing that we know. In his deposition, volume 2, Mr. Carroll testified that he provided these records to other interested buyers. And those interested buyers made an offer of $900,000, $350,000 less than the asking price for that house.
Do we know whether those other buyers requested them or whether Mr. Collier just simply provided them without being requested to do so?
The testimony, Justice Ervin, was that they were his clients and that they requested those records from him.
All right, so he provided these records to the other buyers upon request. Is there any evidence that Mr. Cummings or Ms. Brooke Gagley asked for them?
Not specifically asked for them, no, Your Honor. There is no evidence of that.
Okay, thank you.
But Your Honor, or Justices, the other thing about the maintenance records is that it's unrefuted. Is just like the Everts versus Parkinson's case, the home inspector in this matter said, had I been given those records, I would have done a further investigation or I wouldn't have taken this job at all. Then the other important things to look at is the work. What was actually done? Well, we don't know. Randy Cribb, in his text, says, I think I found it. If this isn't it, I don't know what it is. In his deposition, Robert Carroll said he did nothing to understand the origin of the water intrusion, did nothing to find out what Mr. Cribb did nothing to find out where he did it or how he did it, and did nothing to confirm that, in fact, in keeping with his obligation, that the repair fixed the problem and that it also remedied the underlying issue. And I'm going to talk about that. That is a footnote to the Court of Appeals. The other thing that we know for certain, because we're sitting here today, is that Mr. Cribb did not, in fact, fix all of the leaks. Against those facts, let's look at the Rudd defendants, Brooke Rudd, Jim Goodman, and the Rudd agency. First of all, their fiduciary duty arose de jure by nature of the relationship. And importantly, if we would keep a time basket, that relationship arose months before the exclusive agency agreement was ever executed. Mr. LaRoche said that relationship started on their first substantial contact, and the fiduciary relationship arose at that point. They had a duty to exercise care to discover material facts that reasonably could be discovered. And importantly, the Cummings, under the Brown versus Roth case, could rely on their fiduciary to do this investigation, and importantly, did not have to ask for these things to be done. The economic loss rule fails on this claim for 4 distinct reasons. Number one, as I just said, the agency agreement arose before the contract was ever executed. Number two, even if it arose at the time of the contract, it arose outside because it is a de jure, not a de facto fiduciary relationship. The third reason, if we look at the contract, the subject matter of this contract is for the Rudd agents to provide guidance. The damages in this case are a failure of that guidance causing damage to something that's other than the subject of that contract, in this case, the house. But finally, under Head versus Gould and many cases in North Carolina, there is a professional negligence exception that deals with licensed professionals such as doctors, accountants, lawyers, and I would suggest in this case, real estate agents. So the economic loss rule has specifically been found not to apply in those professional negligence sorts of cases. Now, some interesting facts that you've heard. Robert Carroll did not provide Brooke Rudd these maintenance records. Well, what's important isn't that he didn't provide them. What's important is that she didn't even ask for them. And I would suggest that on pages 35, 36, and 37 of Mr. Walter LaRoche's deposition, that is the expert for Brooke Rudd. He said, number one,
Mr. Kleborowicz, I've read that several times. Would you direct my attention to the exact words that you say give rise to a contention that an obligation to request these records fell upon Ms. Rudd-Gagley?
Yes. So starting at page 34, I discussed with Mr. LaRoche that material facts can sometimes be based upon the type of buyer you have. And he says, answer at line 13, absolutely. And then I asked about a buyer who wants a house that was never part of a rental program. You would reasonably want to know whether or not it was. And he said, yes. And he said that you would have to investigate that. But moving into page 35, my question was, as part of Brooke's duties owing to the Cummings, do you agree that she had an independent duty to investigate this house as a rental investment property? If that's what you're looking for, you'd probably want to get the income information and the bottom line, the net. And that launched us into a discussion of, well, what's the bottom line? And Mr. LaRoche said, the net income, you certainly would want to look at it from the standpoint of investment, certain expense factors and the like. My question, how would the maintenance history of a piece of property, could that be material? His answer, I guess it would depend on, obviously your income statement is going to show any maintenance expenses associated. So I guess in that regard, in terms of your bottom line, your expense cost would certainly be something you'd want to look at. Moving on to page 37, I asked him specifically, when you are representing a buyer who's purchasing the property, are they permitted, being the agent, under the rules as you understand it, to rely on information that's provided to them by the listing agent, or should they make an independent inquiry regarding that information? His answer, probably both. So Justice Irvin, I hope I answered your question about how I get to this idea that for rental property, the maintenance records are important. And Walter LaRoche says she should have done her own investigation and request.
And so you contend that we should conclude that a reasonable trier of fact could find that a duty existed to make an affirmative request for the maintenance records based on the evidence that you just read to us?
Yes, I would submit to this panel that for a real estate agent, by her attorney's own acknowledgement, knew nothing about this house, that taking reasonable steps to find the material facts for her client would have included, when it's a rental house, asking for the maintenance records.
Okay, thank you.
There's also some interesting discussion about what this agency agreement does and doesn't do. It sets forth certain obligations that the Rudd agency has to the Cummings. But what's important about that is several-fold. First, the duties as it relates to finding information and that sort of thing were not limited at all, specifically the fiduciary duty. But secondarily, Brooke Rudd stepped outside of that contract. She didn't provide just the names of these individuals. Brooke Rudd found the inspector, coordinated his inspection, and got him in. She found the electrical contractor. She found the plumbing contractor. She found the handyman. She found the termite inspectors. She did all of this. And so she's outside the context of that agency agreement anyway. And so that's important because, again, what we know is that the inspector said, had I known about this maintenance issue or these maintenance records, I would have done something very differently. We would contend that the Court of Appeals got it correct with reference to this fiduciary duty, that the duty is outside of the contract and that there were facts that should be presented to the jury as to the reasonableness of not just Miss Rudd's actions, but Jim Goodman, the broker in charge as well, that there's questions of fact for the jury as to the fulfillment of their duties. And respectfully, because all of the duties arose before the contract and outside the contract, we believe that the issue of negligence alone should also be reversed. But let's look at Robert Carroll and the sellers in this case. Everts versus Parkinson is a case that touches very closely to the facts here. And what we know is that Robert Carroll and the sellers have a duty to disclose all material facts, what they know or reasonably should know. But what's more important is that they have a duty to not conceal latent defects, those things which are material facts and which, through the exercise of diligence, would not otherwise be discoverable. Mr. Carroll had a duty to not cover that up. And we're going to talk about, again, Justice Morgan, to your question about reasonableness. And the economic loss rule does not apply to Robert Carroll. He's not in privity of contract. His duty arose outside of contract, as evidenced by North Carolina General Statutes 93A-6, which deals with those failures for which a real estate agent could be sanctioned by the Real Estate Commission. And again, his concealment occurred before there's ever a contract. And again, there's the issues of Brooke Rudd didn't ask for the maintenance records. Well, we know he had them. We know that he had looked at them and knew what was in them. And we also know that he was aware that prior buyers offered $350,000 below asking price when they saw him.
Can I just ask, I hope this is falling at the right point in your argument, but what's your response to the position that your clients are contributorily negligent by, in several regards, failures of their own that meant they didn't discover these defects?
And Justice Earls, what we have to look at here is the reasonableness or the level of their diligence, because we're not dealing with reasonable reliance within the context of fraud and the negligent misrepresentation. What we're looking at here is a latent defect. And so the question is, through the exercise of reasonable diligence, could it have been discovered? Well, to Mr. Collier's own point, apparently this thing was so well concealed that all of these other experts, including appraisers and termite inspectors, didn't see it. And we certainly know that our home inspector, who was a general contractor, who was also trained to evaluate water losses after storms for insurance companies, that he did not see it, and more importantly, saw no reason to do any sort of intrusive testing. But Mr. Carroll said, I didn't think that these records were material, and why? And the reason he said is because I thought it was fixed. I relied on Randy Cribb. And to be clear to the justices, that is the only individual that Mr. Carroll said he relied on. Mr. Cribb said, number one, I did what I was told. Number two, he said, I may have found the problem, and if it isn't, I don't know what it is. Now, the Court of Appeals looked at this issue, and they cited in footnote 3 the Real Estate Commission update, and they cited some examples of what a real estate agent could do in order to fulfill the obligation to know that something is repaired. And they laid forth 2 steps, not either or, both and. Number one, they have to confirm that the repair, the specific repair, was successful, number one. And then number two, that the repair cured the problem. They gave an example of fixing a leaky sink or replacing a hot water heater. But here we have years, at least 3 years, of maintenance records and emails showing repeated water intrusion. The cycle, fix it, it comes back, fix it, it comes back. And so here, even if we believe for a moment that Randy Cribb saying, I think I found it and I fixed it, the next question is, well, did they cure the problem? Justice Ervin, to your point, Mr. Moore said there was massive rot, and it evidenced itself during the ownership of Berkeley and Bell by rotted wood and trim, buckled wood, stains inside the house, mold and mildew. Mr. Sears came in 2012 and had to do these repairs. So whether Mr. Cribb stuck his hand in one hole in the dike isn't the end of the inquiry. It's whether did they fix all of the problems that this could have caused? Did they cure the problem?
Let me get you to answer this for me as directly as you can to make sure that I'm understanding your contention, Mr. Cabral. What in your client's view is the evidence that creates a reasonable issue of a genuine issue of material fact as to whether Mr. Carroll knew or reasonably should have known of the extensive water intrusion issues that were revealed when Mr. Moore did his inspection of the property?
Justice Ervin, there's several things. Number one, we have talked about a 15-foot stain into a house. But what we haven't talked about was Mr. Brennan's testimony that said it was 5 feet across. What we know is Robert Carroll was aware of rotten wood inside the house. He was aware of emails going back to 2012 fixing the same issues. He knew that Randy Cribb just the year before had worked on that house and the problems returned. You'll notice I say problems because we don't know if there was 1 leak, if there was 5 leaks. What we know is that there were repeated leaks. And Mr. Carroll was aware of those repeated leaks. Justice Ervin, whether he knew specifically about the massive rot isn't really the inquiry. It's whether or not he could have known about it in the exercise of reasonable diligence. I'll bring up the other aspect of this, that my colleagues focus on East Coast Painting as being another contractor that was consulted. That's not actually who it is. It's East Coast Painting and Contracting. That's their name. That's what we know. We don't know anything else about them because they weren't hired. What we do know is Randy Cribb was hired because he'd do the same scope of work for less money. And nowhere in that scope of work does it say hunt down the source of water intrusion and fix it. That says, I think this might be your problem. But the Court of Appeals also cited the Freeble case out of Florida to give some idea of what types of folks could be relied upon when you have problems like this. But they said they couldn't find any case directly on point. However, there is a case, Stevens versus Heller, 268 App 654. It's a 2019 case. And in that case, the court talks about what would be sufficient for a homeowner to meet their duty of disclosure. And in that case, they said, well, you could include reports and findings of individuals such as licensed engineers, public agencies, licensed contractors, licensed surveyors, and others. And so while we can't find a single case in North Carolina that says relying on a painter like Randy Cripp, who said dozens of times, I'm just a painter. We can't find a case that says that's sufficient, but what we can find is a case that articulates what sufficiency could look like. Said differently, while we may not know what reasonable reliance could on the bare ends look like, we know what the court says the reasonable types of professionals that would meet that disclosure requirement. Now remember, what we're dealing with here is a latent defect. And Mr. Carroll said, oh, I thought it was fixed. But he didn't do anything to confirm that, doesn't know anything about it, but he says, I thought it was fixed. Let's use the example of a air conditioner that leaks slowly during the year, and it does it for many years. Had they filled that air conditioner up and it worked during the summer, well, it worked. I didn't know that it was going to continue to leak just like it had for many years. That would not be an acceptable response. But I want to flip this thing on its ear. The Cummings, Justice Earle, dealing with your question of contributory negligence. The Cummings hired a licensed termite contractor. They hired a licensed home inspector. They had licensed real estate agents, including a broker in charge. They had licensed attorneys, plumber, electrician, all licensed. They had Brooke Road Gagley's fiance, who arguably was qualified to do the work that they were going to do. This is what they have. And my colleagues are saying that was not reasonable diligence. Yet on the other side, we have a painter. So let's flip it on its ear. What if Mr. Carroll had all these licensed individuals who said this house was fine and they missed it? But the Cummings came in with a painter and said, hey, I've looked around and everything looks pretty good by the house. We wouldn't even be here. So when we turn it on its ear, we see that reasonableness is indeed, Justice Morgan, a question of fact for the jury because it's reasonable across the board. And nobody has articulated what the Cummings should have done more. There's a statement that they didn't contact the Anderson window representative. Well, if you read Mr. Cummings' deposition, he said, I'm not sure if I know I contacted him, but I don't know if it was before or after the closing. Wasn't sure. So that's not dispositive. And that is why this issue of reasonableness and reasonable diligence and disclosure of latent facts should be a question for the jury. Let's look at Berkeley and Bell, and for many of the same reasons, the Board of Appeals got it right as to the negligent misrepresentation and fraud. But they made a very specific representation, and that is this. In the residential disclosure form, they affirmatively marked no. There is no known issues with this house, if I'm paraphrasing. However, what we know is they did know about an issue. They knew about it. They were having it fixed. And what we know is they don't know anything about what was done to address it. Mr. Bell, in his deposition, had not even visited the house after those repairs. And so when they say no on this residential disclosure form, they are saying something very different. And the panel should consider this carefully. In the face of a known leak, they're saying, I know it's fixed. And they did nothing to confirm that. In North Carolina, it is clear that if a buyer does not undertake any investigation, then they were not diligent, and the issue of reliance or reasonable reliance on failures to disclose isn't a question. They lose. If you don't exercise diligence, there can be no reliance. But here, we do know that the plaintiffs exercised diligence. They did everything that their fiduciary agent, Brooke Rudd, and Jim Goodman told them to do. Everything. Their experts said, had I known about this maintenance, I would have done something more. And that's what it turns on. If we say that if you don't do an investigation, you're not diligent, but if you're diligent, you can't rely, then they're caught in between with the darned if you do and darned if you don't. For those reasons, we would ask that the Court of Appeals decision be affirmed, and as to the issues of negligence and unfair and deceptive trade practices, which is subsumed into fraud, be reversed. Thank you.
Thank you, counsel. Rebuttal.
Mr. Taylor, you're muted. Mr. Taylor, you're muted.
Thank you, Justice Newby. Saying that there's a chronic water intrusion problem in the house repeatedly over and over again doesn't make it so. There was no chronic water intrusion problem in this house. The only water that came into this house from outside of the house was, number one, when Berkeley had the Anderson doors replaced, when George Bell noticed some rust in those, and they had them replaced back in 2010, 2011 timeframe, as set forth in his affidavit. Read it, record page 354 forward, with supporting documentation. And then later, right in front of the doors on the upper level, not the guest level where this water intrusion occurred, right in front of the doors, when the bamboo floors were put down to replace the carpet, there was some subflooring that Mr. Lucas, the contractor, found and replaced, because he didn't say it was rotten or wet or anything. He said it was flaking, but it was right in front of those doors. This is an oceanfront house in Oak Island. And again, just repeatedly saying there are chronic water intrusion problems in this house doesn't make it so. Then we had this little minor leak that a painter fixed, and it never came back. And Robert Carroll is the one that had those maintenance records. He was our realtor. If he should have given them to him, fine, but that's not a Berkeley and Bell problem. That's a realtor decision. Robert Carroll felt fine with the disclosure statement because it was fine. There wasn't any problem with the house. That leak never manifested itself again until almost.
Mr. Taylor, I'm looking at an email from October 2013 from George Bell to Kim Durham, Robert Carroll, CC Betty Bell, and it lists things to be done on the house. And among those are, number 3, fix the separated rotted wood in the guest room level from the water leakage. It leaked while we were there last week, and it looks like the water may be coming in through the half moon window on the upper floor. And then there's several other references in this chain of emails to rot, and the fixes that are referred to are all painting. Why can't that support going to the jury on whether they knew that there was a problem with rotting wood in the house?
And the evidence is, Justice Hudson, is that the rotted wood was the divider between the French doors that would have been evident for anyone to see. And if George could see it, anyone else could see it. Evidently, it was fixed. We don't have all of the records from everything in this case. We got what we got, but evidently it was fixed because it wasn't there anymore, and George didn't tear the house up to look at it. He lives in Greenville, South Carolina or thereabouts, and he's almost 80 years old if he's not 80. Well,
there's another email in January of 2014 that the wall facing the surviving stress, the lower deck wall and trim around the doors, we haven't touched it. The wooden trim is in real danger of beginning to rot. painting the living room hasn't been done, has never been painted. There's been a lot of water intrusion that has come into that ceiling from wind-driven rain from above and stained it badly about 15 feet into the room's ceiling. It's right in the center of the room and seems to originate on the upper level and flow down through the interior columns. Fix and repair the source of this that's causing the damage. These emails look like they went to everybody involved. So they knew that at least in October and January, or at least that would be something that the jury could look at, correct?
Well, they can if you send it back to the jury to look at, but he's talking about those dividers between the French doors, which were evident to him upon eyesight, and to fix this, he said, fix the source of the leak. It was fixed. And so I don't know what to tell you about that, other than everything was fixed in that house, and there's no evidence that that wood between the dividers was the rotten part. And so he divulged it. It's not fraud. That email is verbatim in the maintenance records, and if it was there for Mr. Cummings to get when he met with the maintenance, the Oak Island accommodation folks before the closing took place. He went over there, met with them, found out about the income and expenses, and he didn't ask for the maintenance records. And all of that was verbatim in the maintenance records. Again, if it's fraud, they're doing a very poor job of the staff.
I hate to interrupt. We've allowed this to go beyond the rebuttal time, but thank you. Next rebuttal.
So that means I'm up. First thing I want to do is talk about these maintenance records that Robert had, and I would call your attention to page 135 of his first deposition, where at the bottom of the page, Mr. Kloborowicz is asking, bottom of 134, he's asking him if Robert, as a dual agent, consider the maintenance records to be information in that work order history to be a material fact. And Robert says, no, based on Chris's why, because everything, if you look back at these work orders, if you look at this, like exhibit 22, it says, quote, completed, unquote. It's remedied. Something has been done to fix that. Someone has taken the proper steps. This is the information that my client had, that now he gets painted as being complicit in some sort of conspiracy to hide something. Randy Cribb's deposition, he said, I don't paint rotted wood. I wouldn't do it. He said, if there was a major, look at page 36, if there was a major problem, would I go back to Robert? Yeah, I couldn't do it. I'm not a carpenter. There's nothing major in that exterior or the interior of the house that you can see.
Thank you. Thank you, counsel.
Thank you.
Last rebuttal.
Thank you, Justices. This is a case where the agent, and specifically the buyer's agent, the Rudd defendants, are, even as fiduciaries, are not guarantors of business decisions, and they're not business advisors. It's not their job to advise their client about whether the decisions they're going to make. They came to them to buy this house. They were interested in potentially renting it. They hadn't decided that. She got them everything that they asked for. She got them everything that was and did everything that was required under the contract. And there's no contention that she violated any of the rules of the North Carolina Real Estate Commission. Again, going back to Krause, if there's no breach of duty, there's no negligence. And that's what we have here. She's also not an attorney and an inspector and an engineer, contractor, a banker, or an appraiser. And all of those kind of people were involved in this transaction, and yet none of them are parties to it. They brought us in to this after the fact. In fact, after the original lawsuit was filed, they came back and amended the complaint to include the Rudd defendants after the Rudd defendants had been deposed as witnesses in the original case. One of the things that was talked about was the inspections and whose responsibility that is. The buyer's agency agreement contract is very specific that the hiring of inspectors is the buyer's responsibility. And if they choose to force that off on the agent will take care of it, but they can't come back later and say, well, you didn't get me a good one, or the one you got me didn't find what I wanted them to find. That's not the standard. You need to look at the contract, and again, look at the Klaus case because I think it specifically addresses the fact that if there's not a duty, there is no negligence. So we'd ask that you.
Thank you, counsel. Thank you to all counsel. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 10:45 a.m. tomorrow morning. God save the state and this honorable court.
Thank you all.
Thank you, counsel.
Thank you.